Hello everyone. In my previous lecture, we discussed chapter 32, and under that, we discussed the execution of sentences. Under execution of sentences, we discussed the execution of death sentences, the execution of sentences of imprisonment, and also the execution of sentences of fine. Now, here we will be discussing about suspension, remission, and commutation of sentences from section 432 to section 435. Now, before I go into discussing these simple four provisions, first let us understand certain terms which we will be using while we are discussing these four provisions. The first one is pardon. That is, when the offender or the convicted person is pardoned, then both the sentence and the conviction is being removed. Now, when we talk about commutation of sentences, it means that it is the reduction in the period of sentence and change in its nature. Now, what we mean changing its nature here, changing its nature is its nature can be changed from death sentence to life imprisonment, or else from rigorous imprisonment to simple imprisonment, or from simple imprisonment to fine. Now, when we talk about remission of sentences, it means that reduce the period of sentence without changing its nature. For example, if the offender is being sentenced to a rigorous imprisonment of 3 years, that can be reduced to rigorous imprisonment of 2 years without changing the nature of the sentence that has been passed by the court. The next one is the suspension or reprieve, which means that stay of the execution of the sentence. And the last one is respite, awarding a lesser sentence in place of one originally awarded due to some special facts. Now, the special facts here may be due to disability. It can also be that the woman is pregnant, etc. Now, let's talk about the powers to suspend and remit sentences, the powers to commute sentences, and the restriction of powers of remission or commutation. Let's take the first one, the powers to suspend or remit sentences. Let's see what powers the appropriate government have here to suspend or remit sentences. Now, appropriate government is defined under section 55A of the IPC, and also you can see the meaning of this expression appropriate government under subsection 7 of section 432. Now, let's see what are the powers of the government to suspend or remit sentences. When any person is sentenced for an offense, the appropriate government at any time, with or without any condition, can suspend or remit the whole or part of the sentence. Then, when an application is made to the appropriate government for suspension or remission of sentence, the appropriate government here may take the opinion of the presiding judge who convicted the person whether the application should be granted or it should be refused. If any condition on which a sentence has been remitted or suspended is not complied with, then the appropriate government may cancel the suspension or remission of such sentence and direct the police to arrest the person and remand him to undergo the remaining unexpired portion of the sentence. Now let's move to section 433, which talks about the powers to commute sentence. Let's see what powers the appropriate government have here to commute sentence. The appropriate government, without the consent of the convict, commute a sentence. It can commute a sentence of death for any other punishment provided under the Indian Penal Code. It can also commute a sentence of life imprisonment to imprisonment for a term not exceeding 4 years of fine. The appropriate government also has the power to commute a sentence of rigorous imprisonment for simple imprisonment for any term to which that person might have been sentenced or a fine. The appropriate government again has the powers to commute a sentence of simple imprisonment for fine. Now let's look at section 433A. Now this section was inserted in the CRPC in 1978. It talks about the restriction of powers of remission or commutation. There are certain restrictions imposed on the appropriate government in certain cases. Now, what are those cases? Where sentence of life imprisonment is imposed on the convicted person, but death is also one of the punishment which is provided by the law, or the accused was convicted for death, but the appropriate government commuted it to life imprisonment under Section 433, then in such case, such person shall not be released from prison unless he has served at least 14 years of imprisonment. Now let's see what the Section 434 talks about. It talks about the concurrent powers of the central government in death sentences. The powers confirmed on the state government under Section 432 and Section 433 in case of death sentences. The same powers can also be exercised by the central government. So this provision talks about the concurrent powers of the state government and the central government in death sentences. Now let's go to the last provision, that is Section 435, which talks about the state government to act after consultation with the central government. Now, while acting under Section 432 and Section 433 of the CRPC, where the sentence for offense falls under these four categories, then the state government will have to consult the central government on what regards we will look here. That is, first one is where the offense was investigated by Delhi Special Police Establishment or by any other agency to make investigation. Other agency here can be the CBI, it can also be the National Investigating Agency, etc. The second category is where the offense involves misappropriation or destruction or damage to any property belonging to the central government. The third category is where the offense was committed by a person in the service of central government while discharging his official duty. Now, subsection 2 of the same section says that no order of suspension, remission, and commutation of sentences by the state government shall not be passed if the person has been convicted of an offense which relates to matters which the executive powers of the union extends and who has been sentenced to separate term of imprisonment which are to run concurrently unless the central government does pass the order of suspension, remission, and commutation of sentences. So what we understand here, for suspension, remission, and commutation of sentences, the powers run concurrently. That is, the central government and the state government pass. State government powers run concurrently, and no orders of suspension, remission, and commutation of sentence by state governments shall not be passed unless and until the central government also passes the orders of suspension, remission, and commutation of sentences. So today here, we have discussed only 4 simple provisions under the suspension, remission, and commutation of sentences from Section 432 to Section 435 of the CRPC.